recording this presentation, which will be up on our website or YouTube at some point. So in case you missed any part of it. For those that are just joining us, I mentioned before, you do not have to share your screen. You're more than welcome to. You could also put chats in the chat box. I will likely not be able to look at it until towards the end of the presentation because it's hard to look at that and also talk at the same time. So thank you. So, you know, we thought that it was good to have, you know, I've been having a couple different Zoom meetings that some of you have been on lately, and I thought it was very timely to have a presentation or a discussion on asset protection trusts. In New York, we had recent significant changes to our home care long-term care program that's paid for by Medicaid, in that New York State is now instituting a look back, whereas previously we only had a look back that covered nursing home care. And so under the new rules, starting likely in October, it could be extended, but October of 2020, for anybody who's looking to get care at home to be paid for by Medicaid, New York State, there's going to be a 30-month look back period now. So now they're going to look back 2.5 years as to any asset transfers. And if there were any uncompensated transfers, meaning gifts, there'll be a penalty imposed on that transfer, which will delay the coverage by Medicaid. So what better time than these new rules to come out, and we're all at home, to talk about asset protection trusts and Medicaid generally. So, you know, and I think the problem here in you know, New York's, you know, is that, you know, we don't have, or federally we have no health insurance program for long-term care. And I think it's a common misconception that we have a health insurance coverage for long-term care, either a federal or state program. So either you have long-term care insurance that you privately pay for, or you have Medicare, or excuse me, you have your own resources to pay for, or you have Medicaid to pay for your long-term care. Medicare does not pay for long-term care. It will pay for some limited coverage if you need some rehab services, and up to 20 days in full, or up to another 80 days with a copay. But beyond that, you're not going to really get any coverage through our Medicare system. So Bernie, do you have anything that you want to add on that? Sure.
I just want to welcome everybody and thank you, Amy, for including me in the program. As Amy highlighted, one of the biggest misconceptions that folks have is if you get sick and old and need care, either in an assisted living, in a nursing home, or even at home, many people assume that, well, you know, I paid my taxes the whole time, I paid into Social Security, certainly the government's going to be there for me. And a lot of people don't like to think about, you know, what happens when you get sick or old. But I think with the recent pandemic, many folks are starting to realize that perhaps we don't have as much control over this as we initially thought. We certainly can't control when or if another pandemic's going to happen. We can't control if or when we're going to have a stroke or get hit by a car or get Alzheimer's disease. But one of the things that we've learned in practicing in this particular area now for more than 3 decades is that the one thing you can control is whether or not you're prepared in case something like this happens to you or someone in your family. And while it may be frustrating to accept the fact, or to be forced to accept the fact that you can't control whether or not you're going to get sick, many of our clients have communicated to us that they take great comfort in knowing that they can do something and we can help them accomplish that goal of taking the necessary steps to make sure that they don't leave their family in a bind and things are not a mess in case something were to happen to you. And with the recent pandemic, many are starting to realize that it could happen to anyone. So what we thought we would do is just give you a few pointers on how you can prepare for what may or may not happen in the future. And certainly we hope it doesn't happen to any of us on this call or otherwise. But some very important steps you can take to make sure that your loved ones are not left cleaning up a mess that you may have left them. Amy's spoken often about making sure you have a power of attorney and making sure you have a healthcare proxy and other advance directives in place so that others can make very important legal and financial decisions for you in the event something were to happen to you. And this isn't just something that applies to elderly or senior people. Anybody who's over 18 ought to have these protections in place. But the focus of today's program is how would you pay for long-term care if you or someone in your family were to need it? As Amy alluded to, the United States of America has a dichotomy in how we treat people who get sick. If you're fortunate enough, and I say fortunate enough, to have a heart attack, then the government has decided that you can go to a hospital, get a bypass operation, which can be several $100,000, and Medicare will pay for it. And as long as you've been working and have paid into the Medicare system, into Social Security, we're all going to get Medicare when we turn 65, or if we become disabled, we'll get it sooner. The problem is Medicare doesn't pay if you need help with certain activities of daily living, like you're older or you become sick and you need someone to come to the house to help you get in and out of bed, or to go to the bathroom, or to make a meal, or do some of the things that many of us perhaps take for granted until God takes them away from us. So if you need help with some of these activities of daily living or custodial care, Medicare does not cover that. There's a very limited Medicare component if you fall, break your hip, or have a stroke and you need some type of rehab in a nursing home. Some clients are able to get a month or 2 or 3, maximum 3 months or 100 days in a nursing home coverage. But the average stay in a nursing home is north of 2.5, 3 years now. So if you have one of these chronic illnesses, such as Parkinson's or Alzheimer's disease, or you just can't take care of yourself, you're basically faced with a Hobson's choice. Either you spend all your money on the cost of care, and believe me, care in the New York metropolitan area is $20,000 a month and more. Maybe you can find a place for $15,000 to $18,000, but by and large, these places are $600, $700 a day, and you can do the math. You're looking at $200,000 a year plus just to take care of yourself. And you don't really need a calculator to figure out that it would only take a couple of years for most of us to lose our entire life savings. And it's sort of unfortunate, because if you had a heart attack, you can go to the hospital and Medicare will pay for it. But if you have Parkinson's, which will last the rest of your lifetime, you know, when people get a chronic illness like Parkinson's or Alzheimer's, it's not like you go to the doctor, take a pill, and you get better. Once you have it for the rest of your life. And the government does not pay for it until you impoverish yourself. So you have to spend all of your money. And in New York, we're fortunate that we've got some of the most advantageous long-term care rules in the country, but they're still pretty strict when you have to confront them and qualify for them. You're not allowed to have more than about $15,000 in your name of non-exempt assets before the government will chip in and lend a helping hand. And worse off, if you're married to somebody, not only are you responsible for the cost of your care, but you're also responsible for the cost of the spouse's care. You are entitled to a somewhat enhanced exemption above the $15,000, but it's not a lot of money. If you're living in Westchester County or New York City, it's about $125,000, and anything more than that, you're expected to pay not only for your care, but for the care of the person you're legally responsible for, and that would be your spouse. So what we thought we would talk about today is, what can you do about it? One thing you can do about it is you can buy long-term care insurance. Long-term care insurance is not something that a lot of folks have. Maybe 7 or 8 million people in the entire country have a policy. And last time I checked, there's about 325, 330 million people in the country. So for whatever reason, These have not gotten a lot of traction, but there are some relatively new products out that involve a combination of life insurance or annuities and long-term care insurance, and we can certainly help guide you through that process. But you're going to spend money. Those of us in the profession would say, well, perhaps it's money well spent because you'd be spending money to protect your family. So certainly buying insurance is one way to try to protect your family against this. Keeping your fingers crossed and hoping you don't have Parkinson's or Alzheimer's one day in the future. There's another way. You might be right, but the odds are you're going to be wrong. According to the Department of Health and Human Services, which is the federal government program or department that administers the Medicare and Medicaid program through the Center for Medicare and Medicaid Services, 70% of us, that's right, 70% of us are likely to need some form of long-term care before we die. So we're going to be in that position of having to write that check unless we do something about it. So what can we do about it? Well, one thing we can do is try to make ourselves eligible for this government program called Medicaid. Medicaid's different from Medicare. Many folks confuse it. We've got a lot of lawyers who contact us for assistance on these cases. They confuse Medicare and Medicaid. Medicare is what you get when you turn 65. It pays for doctors and hospitals, and maybe if you're lucky, you get a month or 2 or 3 of nursing home coverage. It doesn't pay if you have Alzheimer's or Parkinson's. If you have one of those kinds of illnesses and you just can't take care of yourself, either you're going to pay out of pocket, you're going to be one of the very few people who have long-term care insurance, or you're going to look to the government to help lend a hand through the Medicaid program. The problem is to qualify for Medicaid, you can't have a lot of money. I mentioned earlier, it's about $15,000 in New York State. And from my experience, there's only 2 ways that we're aware of that people can become eligible for Medicaid, because most folks, when they come to us, they start out, they have more than $15,000. So the 2 ways are, you can either give it away or you can spend it on the cost of your care. And you don't need a rocket scientist to tell you how to spend it. If you spend it on the cost of your care and then you become broke, then the government will say, okay, you're eligible for Medicaid. But is that really how you want to do it? Why should you be discriminated against because you got one of these long-term care illnesses like Parkinson's or dementia, and you didn't get the heart attack where Medicare says we're going to pay for it? So the problem comes from the fact that the country's made a decision that we're going to treat people differently based on the type of illness that they have. So if you've got one of these illnesses or you're worried about getting one of them, you can either wait till you get it and spend all your money, or you can give it away. Now, lots of people don't, want to give away their money because they're concerned about the fact that, they might need it for something in the future. And Amy, I know we've worked on, many cases together. What are some of the risks that people have if you give your money to your children and, if they get divorced or have a car accident or get sued? I mean, what can go wrong?
Everything could go wrong, and we've seen everything go wrong. So, if you, the well-intentioned child, it doesn't always work out as intended. Your child could get a divorce, could have creditor problems themselves, could die in that unfortunate situation. Now you're dealing with their estate and their will. And if their will leaves everything to their spouse, or even let's say a charity, they weren't married, you're out of luck. If they spend it, what if they just went and spent it? And let's say, the idea is that you're hoping that they'd hold on to it, in case it's ever needed to be turned back, because we are looking, which we'll get into, but some look back periods when we apply for these Medicaid programs. And sometimes we have to break or revoke some of these gifts or these transfers. And we want a mechanism to be able to give it back if we need to.
Okay, so the reality is, and we meet with a lot of people over the course of the last 3+ decades, just about everybody comes in thinking that, they're in the perfect family, and if I give the money to my kids, I won't have to worry. They'll keep it in a separate account for me. But none of the people have ever considered the tax consequences of making the gift. None of them have ever considered the possibility of what looks like a good marriage for the kids end up being not so good, and then all of a sudden your hard-earned money that you gave to one of your children is now being fought over in a divorce contest. We don't like to think about it, but sometimes the kids get sick before us, and the money may be spent on things that you weren't anticipating. Maybe there was a car accident. All kinds of things, as Amy mentioned, can go wrong if you give the money.
And Bertie, just to touch upon the tax consequences, which I think, and for families that are well-intentioned are going to do right by their parents, I think they don't anticipate the big tax consequences, because let's take a house, for example, where in Westchester County, somebody purchased their house in the 1970s. The house could be valued at $50,000, and now it could be $800,000. It could be $700,000. And there's a huge gain in the value of that. And if you transfer that asset to a child, they're going to inherit what you purchased that home for, plus any improvements. And when they go to sell it, they could get hit, and likely would, if it's not their primary residence, get hit with a very large capital gains tax. Same thing with securities, any type of appreciated stocks. So careful tax consideration is a key here when we're looking at this, and these outright gifts to children, which right there oftentimes is not a recommendation, even if you're dealing with the perfect, well-intentioned child.
Yeah, I'm really glad you brought that up, Amy, because just a few weeks ago, I met with some clients, and they were so proud. They came in and said, listen, I'm not sure you can help us because we've already spoken to our accountant. And a few years ago, he was smart enough to tell us to take the house out of our name so that the government couldn't get it and Medicaid couldn't get it. And they were so proud. They had bought this house in Pleasantville in the mid 1960s. And I think they had paid about $35,000 for it. And it was worth $850,000. And they put some money into it, made some improvements. And 3 or so years ago, they'd given it to the children. So they were close to being outside of this look back period that we'll talk about. And their attitude going into the meeting was, we just want to confirm that we did the right thing, and we don't expect we need to do anything else, because thank God for our accountant. And by the way, I'm not making fun of accountants, because I'm a CPA and I think accountants are great. But in this particular case, perhaps they didn't do the right thing, because when they made that gift and they took the house out of the parents' name and put it into the names of the children, when that house is sold, either if it's sold before or after the parents die, the kids now are going to have to pay capital gains on the difference between what they sell it for, $850,000, and what the parents paid for it, $35,000. So that's about an $815,000 capital gain, which could, run into a couple $100,000 of taxes, and it very easily could have been avoided. First of all, if the parents had held the house until they passed away and simply left it to the children or anyone else who inherited it could have sold the house for whatever it was worth at the time of death without paying any capital gains tax. So the entire couple $100,000 of taxes could have been avoided. But what the accountant was trying to help the family with is if they kept it in their name until they passed away and either mom or dad needed a nursing home, well, then there's a good chance there would have been no house, because it would have had to be sold to pay for the nursing home. So he thought he was giving them good advice by getting it out of the name. And while that may have been a good thought, it ends up costing them $200,000 in taxes. And perhaps there's a better way through the use of a trust where they could have protected the house from the Medicaid look-back period, and also preserved the step-up in basis that you get when you die, leaving assets to your children. So let's move on to how you do that. And by the way, this technique doesn't work only with houses. We've done it with condominiums. We've done it with co-op apartments, although, that's a separate animal and more complex with co-ops, especially in New York City, because co-op boards don't like to do that. I know, Amy, you've had a few recent cases on that.
And, and to the point where I'd like to touch upon, I did, and co-ops are, I think they're becoming more amenable over the years than what they used to. because I think co-op boards are like the board members themselves may be getting older. They may be doing their own elder law planning, but definitely I think it's more palatable now to them. Not every board, but more so than when, 15 years ago. Just, I want to pause though, Bernie, for 1 second, because, and just touch upon why do we want to, we're talking about a house here, and yes, it can be other assets, but oftentimes houses and retirement accounts could be families' most valuable assets, and both of which are exempt if we need Medicaid and need long-term care. If you're living in your house and it's your principal residence, the house is exempt. If it's up to a value of about $890,000, if it's valued less than that. As well as your retirement accounts, they're qualified retirement accounts if you're taking your required distributions. So, but I just want to pause there on the house because, or a co-op or, or that type of asset, because even though it's exempt during your lifetime, it does not prohibit Medicaid from putting a lien against or a judgment against the title. So yes, it's exempt during your lifetime and you could live there, but if your intention is for that house to pass to your children or other family members or other beneficiaries at your death, and you have relied upon Medicaid during your lifetime, and Medicaid has put a judgment against that house, then at your death, that judgment has to get satisfied before your beneficiaries inherit.
Yeah, it reminds me, and unfortunately I can't see everyone on the call, but some of us may be old enough to remember, there used to be an old oil filter commercial. I think it was called Fram oil filters. And it was about the importance of changing your filter. And he would come on and say, you can either pay me now or pay me later. So if you don't change the oil filter, then the engine seizes and you get a really big problem. So that's what Amy was reminding me about Medicaid and the house and these other assets. You may get away now because of some rules that treat it as exempt, but it's exempt from Medicaid taking it into account now. But what they don't tell you is when you die, they can sue your estate and take the house from your kids anyway. So it's sort of like, pay me now or pay me later. And we're not only talking about the house, we can be talking about, for purpose of using the trust, securities or other assets. So I don't want you to leave this program thinking that the house is the only asset or real estate is the only asset that can go into the trust. You can use anything. But let's start with, many folks think that, trusts are for rich people, wealthy people. They use them to shelter assets from the government, estate taxes, and all kinds of fancy stuff. Is that true, Amy, or is this something that middle-class folks can use?
It's absolutely something that middle-class individuals can use, and it's recommended in our discussion today for purposes of protecting these assets.
So you've done a lot of these, Amy. I mean, these aren't people with multi-million-dollar estates. What's the average, so that the folks on the call can relate? What's the average typical client that we would do this type of trust planning for?
I would say net worth under a couple $1 million and lower. And sometimes all they may have is a house and retirement accounts, and they may not have an investment portfolio, or maybe they have a small investment portfolio, and or maybe they don't even have a house, but they have an investment portfolio. But I would say under a couple $1 million would be fair.
And so is there an estate that's too small where if someone only has X, they shouldn't even bother calling?
Well, first of all, if you meet the Medicaid eligibility requirements, then I would say, you don't need to consider this type of trust. Also, if we're dealing with, it all depends on, and this is where this planning is so specialized, and there's no one size fits all, because we have to look at the family situation. We have to see if there's a spouse involved and what those assets are, because if we're only talking about maybe a couple $100,000 and the need for Medicaid is immediate, like the spouse is going to the nursing home now, then maybe we wouldn't consider an irrevocable type of trust. Maybe we'd consider some type of other like revocable trust. But so even with smaller estates though, and if we have some time on our side where we're not having an immediate need to go into a nursing home, then I think that an irrevocable asset protection trust should be considered.
So even somebody with maybe 100 or 200,000, it might make sense.
Yes.
Okay,
Yes.
so let's talk about what a trust is. So I know I have accounts at the bank, my name's on them, my wife's name's on them. You can have in trust for accounts at the bank. What is a trust? What does a trustee do? What's the difference between the creator of the trust and the beneficiaries? How does all that work?
So there's different roles. So I like to explain a trust as being its own entity. It's its own individual or own entity, and it owns assets. And the person who creates the trust, we're typically referred to as the settler. That's usually you. If you're coming to us for planning and you want to protect your assets, you're the one that's creating the trust. Now, if you happen to already be incapacitated, and we're not anticipating nursing home in the short-term future, then if your power of attorney gives proper authority to your agent, then your power of attorney can establish the trust. So a settler or the creator is the person who's establishing the trust and funding the trust. And then we have a trustee who is not, with these type of trusts that we're talking about today, these irrevocable trusts, a trustee is not the settler. So it is typically not the spouse and not the settler. Oftentimes it's a child or other family member or very close confidant friend. And then we have the beneficiary. The beneficiary, oftentimes these trusts are structured so that if there's income earned, let's say you transfer some stocks to the trust and there's dividends and interest earned, you could be the lifetime, you're the settler, the person creating the trust can be the lifetime income beneficiary. So you get the income, or maybe you direct so your spouse could get the income. Then we have remainder beneficiaries, and the remainder beneficiaries are the individuals who would inherit the assets remaining in the trust at your death. And oftentimes those may be your children. And so those are the various roles when we're looking at this trust.
Okay, so when we're talking about a trust, we're basically talking about having a separate entity. So instead of the assets being held in your name or your kid's name, the assets would be retitled and it would say the John Doe 2020 Trust. And that has a legal consequence. So you no longer own those assets. They're owned by the trustee. But if the trustee is going through a divorce, or the kids are getting through a divorce, or the kids get sued or have creditor problems or die, does that affect your assets in the trust? Is it treated the same way as if you're giving the money to the kid?
Not at all, because your trustee does not personally own the assets. Your trust does. Your trustee manages the assets and has a fiduciary responsibility, but if their own personal life doesn't come into the trust.
Okay, so the one benefit of putting the money into the trust instead of giving it to the kid, just to review, is A, you save potentially a couple $100,000 in taxes depending on how much your home is worth. Because by putting it into the trust, this problem of having the basis equal to what the parents paid for is solved, because when you put it into the trust, the IRS gives you an exemption if the trust is drawn up properly, so that when the kids sell the house, they pay no capital gains on death. Isn't that right, Amy?
That is correct. Correct.
Okay, so go ahead.
I always like to say to our clients, I really say, for Medicaid purposes, you no longer own the asset, but for IRS purposes, you still own the asset. I think it's easy to conceptualize that way, because you still get certain tax benefits, because the way that the trust is structured is you still own the assets for IRS purposes and for tax reporting, for step up in basis. If you sell your house, the trust is not you, but if the trust sells your house during your lifetime and it was your principal residence 2 out of the last 5 years, you would get $250,000 or $500,000 offset of any gain. But for Medicaid purposes, you no longer own it because it's been retitled into the name of the trust.
So I think that leads to a lot of the confusion. After we do the trust, the person brings it to their accountant and they don't understand who's paying the income on, who's paying the taxes on the income from the trust. Explain how that works.
So the trust is set up as what we refer to in the legal world as a grantor trust. And what the grantor trust rule means is that the grantor, the settler, the person creating that trust, still owns the assets for IRS purposes and will report any income. First of all, the income would likely be distributed, if it's set up this way, would be distributed out to the person creating the trust, the settler. and all the income is reported on his or her personal income tax return. And so that is how we structure it for purposes of like the, who owns it and how it's reported on the tax return. And every year, this time of year, in the last couple of months, I routinely, speak to accountants who call me up and say, well, so-and-so set up this trust last year, and, how do I complete the form? Well, and so, or the tax return. And so I walk them through that. And, and that's where it's important for us to be part of the team and to know who the accountant is and to work with the accountant. The other time, sometimes actually the way that we structure this trust, we don't even have to get a separate tax ID number for the trust. We could use the person's social security number, and therefore there's no concern or confusion about a separate tax return having to be filed.
Okay, so I don't want to oversimplify this because it is complicated, because, I mean, look, you wouldn't have to go to a lawyer if it wasn't complicated, but by transferring assets into a trust, you save the capital gains taxes, you protect the assets from the creditors, lawsuits against kids or divorce or any of those bad things. And if you transfer the property into the trust more than 5 years before you or your spouse needs a nursing home, Medicaid doesn't count the assets in the trust. So the same way as if you had given the house or the other assets directly to the kids, there's this 5-year look back, which also applies to the trust in most, but not all cases. There are some exemptions that might be applicable, especially if you had a child with a disability. You may be even able to avoid the 5-year look back. So that those are specialized circumstances, but worst case scenario is you would transfer it and you would start the 5-year clock. So I'm going to get to some of the questions, but someone just asked a very interesting question that happens to be on point for what we're talking about now. And Walter, I'm going to get to your questions in a second, but I want to answer Susan's now. Other than the cost, the fees to set it up, which are far outweighed by the benefits, there is no downside to doing this. It's not like there's a trade-off. Well, if you do this, you're giving up X or you're giving up Y. It's having your cake and eating it too, because let's say you do this and you don't make it the 5 years. You set up the trust, and within 5 years, it turns out the person needs the nursing home. And let me just take this opportunity to point out that what Amy and I are speaking about today is New York law. Because Medicaid is a jointly funded federal and state program, each state has their own little nuances where they deviate slightly from the federal law, but it's still permissible. So the laws in New York are different from New Jersey, different from Delaware, different from Connecticut. And it's really important that we all work with people who are experts in that particular state's laws. So what we're talking about is in New York, there is no downside. Putting aside the fact that you may not benefit from it. And here's how you may not benefit from it. Let's say you set up the trust and the person dies and never needs a nursing home. Well, then technically you've set up the trust, and one could argue you didn't need it. Although I would say, well, one of the benefits of the trust that you'll get is because the property's in the trust, you won't have to go through probate. So you did get a benefit from it. Or if you became incapacitated before you died but didn't go into a nursing home, another benefit of the trust is whoever you appoint as trustee would have an easier time managing your assets and your real estate than if you didn't set up the trust. So I honestly can't think of a reason not to do it if you're in a position where you're prepared to give up control of your assets. Now, I wouldn't say if you're 50 years old, you should be setting up one of these, because why give up control? I mean, you have to look at this realistically. And I would say that as people go into their 60s, they start hit the sweet spot for being prime candidates for doing this in the 60s and 70s. Once you get into the 80s, it then becomes a sort of a catch-22, because you have to make sure, if you want to get value out of this, that you're going to make the 5 years. And actuarially speaking, you know, somebody who's 88 has less of a chance to make it the 5-year period than somebody who's 72. Again, it doesn't mean you shouldn't do it. It just may make the cost benefit analysis a little bit different, where if you're going to spend a few bucks to set one of these up, and the likelihood is you're going to go into a nursing home within the 5 years, then, you know, maybe it's not worth the expense, but I don't have a crystal ball. Some people in their 70s don't make it 5 years. Some people in their 80s or 90s do. It's just you have to go into it with your eyes open. But there really is no downside to trying this. Although I would say, if somebody had, for example, $500,000 in their name, and they came to our law firm for advice, we would never say to them, put the entire amount in the trust, because you still need money
Correct.
to buy groceries, to go on vacation, to give the grandkids money, to do whatever you want to do. So maybe somebody with 500 would put in 200, 250, 300, so that if they did get sick, the government wouldn't take it all. So you'd have some insurance, some protection that at least your spouse or loved ones, your kids would get something. So that's a private discussion. You know, you have the trust, you decide to do the trust, and then you have to decide how much money you want to put in the trust, and then which assets do you want to put in the trust. For folks who have cash or certificates of deposit or other liquid resources, we got to go through the analysis. Maybe it's more appropriate to put the house in, or to put the stock in that was appreciated in excess of what you paid for it. So that's a completely separate question. So benefits, you know, the no capital gains, the protection from the creditors. If you make it for the 5 years, then the way it works is, let's say you put $500,000 into one of these trusts, and you made it to 5 years. So you did it, and you didn't go into a nursing home for 5 years. Then when you do go into the nursing home, if in fact you do, or you need care at home or assisted living or wherever, then for purposes of determining whether you qualify or not for the Medicaid benefit, and whether or not you have less than $15,000 in assets, all of the money in the trust does not count. None of it. So it's separate. It's in a different pile, and the government says, well, because you did that 5 years ago, if you got 15,000 in your name and 500,000 in the trust, for purposes of Medicaid, all you have is $15,000. So that's the beauty of it.
Mm-hmm.
You get the tax benefits. There's no downside to it. You're not worse off than having made a gift or keeping the money in your name. In fact, you're a lot better off. You're protecting the money in case something happens with your kids or something happens to you. You just have to do it right. You have to put the right amount of money in. You have to put the right assets in. And like Amy said, it's not one size fit all. Every client who comes in to meet with us, you know, doesn't walk out with a boilerplate trust. If the trust is the appropriate thing to do, then certainly we would consider what type of trust. We would draft one specifically tailored to your particular needs. The point here was just to give you an overview of the powerful benefits that a trust can provide. And Patty and Walter, I am going to get to your question, don't worry. But Patty, you asked a question, if you have long-term care insurance, is it still worthwhile to do this? And the answer is a resounding yes. The odds are, if you have long-term care insurance, in fact, that may even make you a better candidate to do it. Let's say you had a long-term care insurance policy that paid for long-term care for a period of 5 years. Then you're a perfect candidate, because then you could put even more money in the trust, because even if you don't make the 5-year look-back period, you would have the insurance to cover it. But the reality is most folks don't have insurance, and if they do have the insurance, they probably have a 3-year policy or
their daily
less.
benefit is, I just came across somebody, their daily benefit is only $200 a day, but they have a $5 million policy, but they could only get paid out, you know, $200 a day. So, and an average cost of a nursing home day in the nursing home could be $600 to $700 a day. So, sorry, I didn't mean to interrupt you, but I just came across that last week with a client. So it's, yeah.
Okay, you're 100% correct.
Mm-hmm.
So just because you have, I'm glad you brought it up, just because you have long-term care insurance, it may not cover the entire amount. Maybe you bought a policy, but it didn't have an inflation rider, or as Amy said, it's $200 a day and the cost of care is now $600 a day. So if you have long-term care insurance, since you brought it up, there have been a lot of discussion lately about policies getting a price increase. Where it happened to my own mom, where she got a notice from the insurance company. They raised the premiums 30%, then they raised it 50%, and you know she couldn't afford it anymore. As a last resort, you would cancel it. but only as a last resort. Do not cancel the policy without having it reviewed by a lawyer, by somebody in the insurance field, because maybe there's a way to restructure the policy so that it's maybe you reduce the benefit from $400 a day to $300 so that you can afford it. But don't give these up, because if you give up the policy, here's what happened. You paid premiums for 30 years, the insurance company kept your money, and then you cancel it when you're closer to needing a nursing home, and they're never going to have to pay. So if you have a policy, please don't cancel it without getting proper review. I think what I'm going to do now is, because the purpose here was to get to everyone's questions, and I see we're getting a lot of questions. So I want to get to some of these. We're going to get to Ed's question. When was the last time these types of trusts were affected by changes in the tax law, New York state law? The last change I'm aware of was in 2006, where from a federal perspective, it used to be the look back period for trusts was longer than it was for outright gifts. So if we were having this conversation in 2005, and Susan asked the question of whether or not there was a downside. In 2005, I'd be able to say to you, yes, there's a downside. If you give the money to your kids in 2005, then the look back period was only 3 years. But if you put it in a trust, it was 5 years. In 2005, they changed the law and made a 5-year look back, whether you put it in a trust or whether you make a gift outright to your kids. So they actually made the case more compelling for trusts. So there have not been any recent changes federally or in New York State in the tax laws or the long-term care laws that would affect trusts. The only thing that I can think of that Amy alluded to earlier is it used to be that maybe you didn't need a trust if you were not going to go into a nursing home, but you only needed care either in an assisted living or at home. And I don't know how you can make that decision. Nobody's got a crystal ball, but if you were to take that gamble, it used to be maybe you didn't need a trust. But the governor just had a budget bill enacted where he changed the rules on those as well. And now these asset protection trusts are going to be equally as applicable for cases of home care starting October 1st. So if you or a family member might need home care in New York State, it is certainly going to be in your best interest to work with somebody to file that application before October 1st. Because, and while the October 1st deadline may change due to COVID-19, they may push it back into 2021, but no guarantees yet. It's absolutely in your interest to file it now so that you're not subject to these new changes to the Medicaid home care rules. And I would encourage you to work with somebody that's familiar with the rules and understand what the pros and cons are now. Let's go to the range of the cost for these services. Again, we don't do cookie cutter stuff. Each case is different, but I want to give you a better answer than that. You'll need to sign up for a consultation. Depending upon who's handling the consultation, you'll pay anywhere from $500 to $1,000 for the initial meeting, which will last between 60 and 90 minutes, where we'll get the opportunity to hear what your needs are, what your wishes are, what your desires are, ask the appropriate questions, tailored to your circumstances, and then recommend a plan to you, which may or may not include a trust. At the end of that meeting, we're actually doing something new during the pandemic. We're trying to be sensitive to people's needs here. Historically, we do not or did not apply the consultation fee to the cost of the overall work, because our feeling was you were free to accept our advice or not accept it and move on and do whatever you wanted to do, and you would just pay the consultation fee and we can part as friends. But during the pandemic, we've made the decision to actually apply the consultation fee to the cost of the overall work. If you decide to go forward with it, again, no strings attached. If you don't want to do it, you can simply pay the fee and move on. But if you did find benefit in doing it, we would apply the fee. And again, depending upon the complexity of your estate, you can expect to spend anywhere from a couple to a few $1,000s on this. Again, co-ops seem to be more labor intensive, so you'll probably end up spending more if you have a co-op. Houses are a little bit more complicated than if you just had cash in the bank, because there's work that has to be done with the deed. But I would say the overwhelming majority of these cases, but for some of the co-ops, at the end of the meeting, you will know exactly what it costs. We don't charge you extra for phone calls or emails or correspondence. If we're involved in giving advice and it's a potential guardianship or a litigation or things like that, we really have no choice but to charge you for our time. But for something like this, where we have a pretty good handle on how much time it's going to take, most, if not all of this work, we can do on a fixed fee basis for a couple to a few $1,000s. Does that sound right to you, Amy?
Yes, I agree with that.
Okay, so let me, go ahead, sorry.
You know, just one thing, because this was one of the questions that I got emailed to me, and it just kind of goes hand in hand, you know, and this was related to Living Trust, which we're really not talking about today, but, you know, can we do everything from beginning to end via video conference right now? And so the answer is yes, because I have become very familiar with Zoom or whatever the client's mode preference is, whether they're not as a fan of Zoom and it's FaceTime or Skype. But we typically can, because even right now we could execute documents via video conference. The governor has put into place for a limited period, it's not permanent at this point, but a limited period, the ability to execute documents via video conference. We just have to be, as your lawyer, we have to be careful to just know the circumstances on the other side to make sure there's no undue influence or, you know, or any fraud, you know, anything that's you're being unduly influenced on your side. But yes, we could do everything beginning to end via video conference.
All right, we got a bunch of questions, and before I run through these, and I want to get to all of them if I can before the top of the hour, just one more point on the legal fees. I know it's an issue for many folks, but just think about what's more important other than your health and the health of the people you care about, than making sure that if something were to happen to you, that things are set up for them to make it as simple as possible for them to take over, manage your affairs, and make sure you get the care you need and deserve. So while it certainly makes sense and we appreciate clients doing their research and their homework, it reminds me of that old commercial, an educated consumer is our best customer. We want you, in the days of the internet, we want you to ask questions, come in and be ready to go. It helps for a smoother meeting and consultation, and we can get down to brass tacks a lot quicker. Let's go on to some of the questions. Walter asks, what if the need is now spouses in full Alzheimer's and may need to go into a home within 12 months? Okay, you're in a completely different webinar for that. The trust is not going to work for you. If you have an immediate need and you know you're going to need care in the next 12 months, you're going to have to go to Plan B. And if you're married, that's probably going to involve a spousal refusal. The good news is you're still going to be in a place where you could probably protect all of your money. There are certain consequences of doing a spousal refusal. Some of the counties, in particular Westchester and New York City, have been more aggressive than others in seeking to recover some of the cost of care that's provided under spousal refusal. But long story short, if you do a spousal refusal, we've had clients pay anywhere from 0 to 30 or 40 or 50 cents on the dollar in the worst case scenario. Again, no guarantees, but the counties are reluctant to sue seniors for the cost of care on a spousal refusal. Not to say they don't, and it's not to say they won't. It's just that they do, we're usually able to negotiate some kind of settlement that takes into account your particular situation and your need to have a quality of life. Amy, you on board with that?
Yes, and just to break down a little bit further, what you're saying is, and really referring to nursing home care at this point, is that if you were to privately pay for a nursing home, you may spend $15,000 to $20,000 a month, whereas Medicaid negotiates a lower rate. So when you get a spousal claim, or you get, Medicaid's trying to get reimbursed for what they're paying, so they may be paying $10,000 a month as opposed to you $15,000, $20,000. So you would be working to negotiate the lower, you would get the lower rate.
Yeah, so worst case scenario, somebody who's would be paying $15,000 to $20,000 a month, paying privately at a nursing home, might end up paying $3,000 or $4,000 or $5,000 a month on a negotiated Medicaid settlement. So it's a significant discount. That's assuming you're one of the people they even seek recovery from. All right, Walter had a follow-up question about annuities. Are they also considered retirement accounts? Well, I'm assuming you're talking about an annuity that's not in a retirement plan. In order for an annuity to be protected, it has to be Medicaid compliant, which means the state has to be the beneficiary of the annuity. So in order to answer that question, we would have to look at your annuity. We would ask that you bring that into the meeting so we can review it. And if it's actuarially sound and the state is the beneficiary, then it's possible the annuity could be protected, but there may be a better way to do it than actually structuring as an annuity. And for some clients, it actually makes sense to take the money out of the annuity, assuming you don't have surrender charges, or those have to be taken into account. So again, that's a case-by-case thing. I can't say that annuities are considered retirement assets and thus protected, but they may be if it's the right type of annuity. So then Carolyn asks, how would the asset protection strategy differ for a client who has already established an S&T for a disabled child? Well, I alluded to this earlier. If you're somebody who's considering creating an asset protection trust and you have a child with a disability that would qualify under the Medicaid and SSI rules, you may need a different kind of trust. So the S&T that you've already established may not qualify as what's called a sole benefit trust. And I don't want to get too technical with the legal mumbo jumbo, but if it's a sole benefit S&T, then you could not only transfer those assets to the trust and preserve the child's SSI and Medicaid, you'd also be able to do that and not have a 5-year look back. So the answer is it's possible that the S&T would work, but it's also likely that you would need a different kind of S&T in order to protect it. Amy?
Yes, and I'd say that that works well for families who only have one child, or all their children happen to have eligible disabilities to qualify for that. That type of plan is not work as well if you have multiple children and only one of them happens to be disabled, because then you're unintentionally possibly disinheriting your other children.
Correct. So you need a way to make it up or get comfortable with it. So Susan asks, how does this trust work as compared to the trust that must almost be in the trust or you would go off the cliff in New York upon your death? Okay, so if you're lucky enough to have that kind of money. So New York has a strange rule that you don't pay a state tax unless you have more than approximately $5.5 million. But unfortunately, if you have $1 more, you don't just pay on that $1, you could bring in potentially the entire amount depending upon how much over you are. This is a completely different kind of trust, Susan. If somebody had that kind of money, Amy and I would definitely work with them to make sure we didn't go off the cliff, because that is classic malpractice. If we're causing a client to go off a cliff that would otherwise not be subject to it, you definitely want to be careful about that and not cause an estate tax inclusion if there were a way to beat it. So this is not only about the Medicaid and the cost of long-term care. You also need to work with advisors who are familiar with the tax laws, because sometimes the tax law is more important, sometimes the Medicaid law is more important, and sometimes they're both important. And taking into account the cliff for New York State is one of those situations where you'd have to take into account both. So Lauren asks, do most New York City co-op apartments, are they eligible for the APT? I would say in my experience, most is probably a little strong here. But a few years ago, it was hardly any. Now it's a fair amount. So what I would recommend, if we're going to do a asset protection trust for somebody who has a co-op, instead of incurring the fees and spending the money to create one of these trusts and then find out that they don't do it, we contact the co-op board and the attorneys for the co-op board and take their temperature. And say, okay, here's what we're thinking about doing. Is this something you could approve, and feel them out on it? And then we could know whether or not it makes sense. And we've done that with a fair amount of success recently. So that I would just say proceed with caution. With a trust give back to Medicaid, is life insurance worth it? Well, okay. So these kinds of trusts that we're talking about don't have, you have this, I mentioned this pay me now or pay me later. If you set up one of these asset protection trusts, because they pass outside of probate on your death, there is no give back to Medicaid. So you would never have to pay back Medicaid out of these trusts. It would go directly to your family members. So you wouldn't need to consider life insurance. But if you had life insurance and a family member was a beneficiary, since that passes outside of probate, that too would escape Medicaid or state recovery. You just have to be careful if the insurance policy had a cash value and the cash value was more than what the Medicaid exemption was, then you can't, you would have to figure out how you're going to treat that and either spend it down or transfer it prior to applying for Medicaid. Nick asks, do I anticipate any future cuts to Medicaid due to the New York State budget deficits? Well, I'll tell you this, I've been doing this kind of law for 35 years. I've never seen the state or the federal government go back to the way it was. Whenever they change things, they make it worse for us. So I could say pretty confidently, I don't know when, but that there will be changes. And when there are changes, it's going to be harder to do what we can do now. Let's face it, people need money. The states and the federal government are probably going to go bankrupt after this pandemic. And I was really surprised to see that, but disappointed, I should say, that New York State, despite the current environment, still chose to try to balance the budget on the backs of seniors and those with disabilities by enacting these draconian Medicaid cuts. You know, maybe they could have given us a break till next year or the year after, but c'est la vie. Can't cry over spilt milk. So I would say, yeah, I probably anticipate future cuts, which is more of a motivation to act now and not wait. So if an RMD from an, go ahead, Amy, sorry.
Oh, no, because actually, I think you're going to get to that one because I also had emailed to me a question that's similar to that about if somebody has, if their income's sufficient enough that it covers the cost, let's say it's $10,000 a month and the care costs $10,000 a month, can they qualify for Medicaid? And I think that's similar to the large IRA distribution as well.
So Herb asked if an RMD from IRAs is large, say 100,000, is there any way to protect the distribution? Unfortunately, Medicaid's the payer of last resort. And if the required distribution exceeds the cost of care, you're probably going to have to spend the distribution. Now, the good news is the recently enacted CARES Act put a hold on RMDs, not only from individual retirement accounts, but also from inherited IRAs in 2020. So you won't have to take a distribution this year. Next is Karen, says if the home is in the trust, then any bills pertaining to the home will be in the name of the trust. If the client has a pooled income trust, can these bills be submitted to the pooled income trust for payment, even though it's not in their name and owned by the trust, which is not technically client? Also, it's now an asset not taken into account for Medicaid, so is allowable. Okay, so pooled income trusts are different from asset protection trusts. A pooled income trust only works for home care. And there's some question now as to whether or not it's going to continue to work, but we believe the answer is yes. We're waiting for clarification from the state on that, but we believe it's yes. So a pooled income trust is a way to avoid the Medicaid spend down if you're getting home care. Completely different topic, and perhaps, Amy, it's not a bad idea for a future webinar, how pooled income trusts will work with Medicaid home care if you have the time.
That's a good idea. And also, I think that another topic for because we've gotten a lot of questions about living trusts and revocable trusts, and we could spend an entire hour on that as well. So perhaps we'll have another session and talk about living trusts and avoiding probate, especially now that our courts have been closed for going on 5 or 6 weeks, where we can't file anything, we can't file probates, we can't do anything at the court, that these living trusts are becoming more attractive. It's just kind of beyond the scope of today's meeting, talking about asset protection trusts, because living trusts or revocable trusts is your money, and it's not meant to be a Medicaid qualifying trust.
So just to be clear on the answer to the question, a living trust is different than an asset protection trust. An asset protection trust, it has to be irrevocable. And of course, a living trust is something that's revocable. But having said that, even though an asset protection trust has to be irrevocable, there are ways to draft it where your family can get the money out for a rainy day. And that's something we would talk to you in the privacy of a personal consultation. And let me just end by saying, I hope everyone stays safe and well. We meant what we said, that during the pandemic, however long that may be, we'll offer you the opportunity to apply the consultation fee to the cost of whatever work we can do. And, you know, this is one of those things where I can't think of a reason to do it later rather than sooner. But if somebody thinks of one, let me know, because the sooner you do it, you can start the 5-year clock ticking. On that note, I really appreciate everyone taking time out of their day and being patient with Amy and I as we got used to this technology. Thanks so
Yes.
much. And we look forward to getting back to whatever normal is going to be when that happens. So long, everyone.
Thank you.